Book Review Part 1, Negotiation Mythbusters, Rethinking Everything You Know About Building Strong Agreements. A conversation with mediator Sylvia Mayer. That is our topic for today, part of the series, Mediation Book Reviews. Welcome to the Lawyers and Mediators International Show and Podcast by InstantMediations.com, where we discuss law and conflict resolution topics to educate both professionals and everyday people. Catch regular episodes on YouTube, the Instant Mediations app, and anywhere you get your podcasts. Just remember, nothing in these episodes constitutes legal advice, so be sure to talk to a lawyer, as cases are fact dependent. Hey everyone, this is Mac Pierre-Louis, attorney, mediator, and arbitrator working throughout Florida and Texas.
And Natalia Łowska-Czajka, advocate, mediator, and arbitrator from Warsaw, Poland.
Hi, everybody. My name is Sylvia Mayer. I'm an arbitrator, mediator, and attorney located in Houston, Texas. Thanks for having me.
All right, Sylvia, good to go at it again. So, we are going to be doing another book review today, this time on Negotiation Mythbusters. And if you are watching the YouTube channel, you can see my screen share just now. If you are listening, please be sure to check out the channel so that you can see the screen share. But this is a book by Dan Oblinger and Alan Zhang. Now, the title is Negotiation Mythbusters, Rethinking Everything You Know About Building Strong Relationships, Strong Agreements. And the thing about it is, like any good work out there that talks about negotiations and how people can make good deals, go to mediation, go to arbitration, and get something out of it, we're always wanting to investigate these books and get the pearls of wisdom that they provide. So, Sylvia's done the hard work, of course, of not just reading the books, but also writing some articles on it. And Sylvia, I know one of the articles you wrote on July 8th, 2022 was published on your website. Website, by the way, is smayerlaw.com. One of the articles is Mediator Insights Bursting Bubbles by Challenging Mediation Truisms, Part 1, where you go into different myths that you get from the book. And before I give you the floor, Sylvia, so you can talk a little bit about your article and a little bit about why this book has made such an impact on you. Wanted to, you know, I was reading up on the book and they go through a list. There's like 30 different myths the authors believe people hold on to that aren't actually true. So I was looking at the list, and here are some of them that they list. Okay. That it's a myth that trust is necessary to have a good negotiation, that it's a myth that negotiation is a win win. They say it's a myth that a good negotiation means everyone gives up something that they want. They say it's a myth that knowledge is power. It's a myth that you're supposed to be always empathetic. It's a myth that trust is necessary. And I know this is the one you're going to hit on today as well, Sylvia, that it's a myth of just ask all the right questions. That doesn't necessarily work. That aggressive negotiators get what they want. That negotiation is manipulation, that everything is a negotiation, and finally, that negotiations are about leverage and power. That those all those things are myths that have been fed into us either by society or maybe some trainings we've gone to as mediators and conflict resolution experts. And so let's go, Sylvia. Let's discuss which one of those are myths. Do you agree? And the floor is yours.
Well, thanks for that introduction. So yes, this book goes through 30 different commonly accepted truisms, or in their view, myths about negotiation. And by extension, we as mediators can draw from this in terms of mediation. And today I really want to focus on two things: the myth of trust is necessary, and the myth of the best negotiated outcome is a win-win. But underlying all of the 30 different myths are some very central components or central elements of their thinking and approach to negotiation. They believe that a negotiation, to be effective for both parties and productive, that you need to really focus on safety and consent. And that with those two foundations, it then lays the predicate for everything else. And so I picked trust is necessary as the first of the myths to really focus on for two reasons. One, literally almost every mediation training I've ever gone to, they say trust is necessary. And part of our job as a mediator is to build trust. And these guys blew that idea out of the water. But also, two, the reason they blow it out of the water ties back into these central themes that they say are the foundation of any good negotiation of safety, consent, and connection. So let's talk about this a little bit. If you step back and you just think for a second, when you meet a stranger, the first time you meet them, hi, I'm Sylvia Mayer. Do you trust me? Probably not, because you just met me. You don't know anything about me. When you're in litigation and somebody just sued you for something, they're accusing you of whatever. They're accusing you of having defrauded them or breached their contract, or it's a divorce and parties are separating their property, but also negotiating custody of their children. Do you trust them? Do you walk into the room and say, yeah, you just sued me for $1 million, but I trust you? Probably not. But even though parties may not know me before they come to mediation, and even though they may have a huge trust deficit between them, we as mediators help parties find resolution every day. So how do we do that? Because we don't have trust when we start at the beginning of the day. Well, we do that because we use what I call trust building skills. And in this book, the authors really focus on the critical components of what we think of as trust building are safety, consent, and connection. And by that, what they mean is if you have a negotiation where one party does not have the ability to say no, meaning the right to consent, it's not a negotiation, right? That's not a negotiation. You're not negotiating with somebody who has absolutely no ability to change the outcome of the conversation. So what you really need to be doing is recognizing the power of consent, that each side has the right to say no or yes, connecting with them, and then through those things, providing a sense of safety. And when you do that, then people open up. They open up and share information, but they also open their minds so that they become more receptive to receiving information, but also to finding some kind of compromise or path to resolution. And so, they really focus on this in the context that you really can't focus on actually having lifelong enduring trust. Instead, what you need to focus on in a negotiation, or for us, a mediation, is connecting, creating a sense of safety and openness, and recognizing their right to consent. So it's really a novel thought. I don't know. What do you think about all this?
Yeah. The thing is that really, sometimes, and there are these people that build trust after testing people for years, and then believing in a myth that suddenly in a 4 8 hours mediation, you are building trust with someone who, for example, has this sort of character. They need to see, they need to give them other people tasks so that they can actually experience if they are trustworthy. And then you're just a mediator there for, let us say, the Texan model 4 hours. What sort of trust are you having? I am understanding that I'm shifting this trust issue into those little components. Again, making people feel safe, feeling them, making them feel connected, right? uh, is actually the basis of something that would be called it contemporary, temporary trust or situational trust. This is very, yeah, eye-opening, I need to say.
No, absolutely. I think I was one of those people who have gone through mediation trainings, and I've gone through multiple trainings in Texas and Florida. So, of course, trust being a key component is an absolute, um, prerequisite, was always something that we just accepted because you gotta think about it. It makes sense, doesn't it? I mean, only when people trust each other are they going to be willing to give something because they're going to believe that they're getting something back that is worth of something similar value. That's how my mind works anyway. But the whole situational or temporary trust, or trying to create the circumstances where people can, you know, get engagement this way, okay, I'll accept it. And if I buy it, then as a mediator, I should be able to help parties be more successful and not feel that I have to get them to have lifelong trust when it might not be necessary. If I can just help them get a deal that can then hopefully at least teach them how to build trust um, after that. So, yeah, Sylvia, you want to add something before
Yeah,
we
I
go to
did.
WinWin?
So I think it's really important because I think it is unlikely, say in a full day mediation, it is unlikely you're going to take two people who walked in the door who maybe even hate each other, but who, if nothing else, have a huge trust deficit, and to think that by the end of the day they now trust each other. Instead, what they're doing is that they are getting comfortable, feeling safe with you as the mediator, with the process of mediation, and with the terms of an agreement. And so sometimes that I really think once people are open to having the exchange of ideas and they're open to reaching an agreement around terms, the next big step to provide that safety is embedding in the agreement what I call guardrails. And so you need to make it so the agreement is durable. So when it walks out, even if they continue to have a trust deficit going forward, there are mechanisms in place that allow the agreement to survive and allow the agreement to function. So it's just a different way. To some degree, it may be semantic, but it's a different way to view what we're doing and getting parties comfortable and getting them to a place of compromise or resolution.
So,
Thank you.
having said that, I think we should be heading into our next myth to fight today, which was negotiation is a win win game. Tell us why it is not.
Right. So this is really interesting. The way they explain it is that we all operate under this premise that the best possible outcome of a negotiation is a win-win. But when you step back from that and you think about, well, so what does win-win mean? Win-win is a concept that comes from game theory. And game theory says that some games are players are playing against each other, and you have a winner and a loser, which is amongst the players. And some games are cooperative games. But even in a cooperative game where the players are working together, they're playing against the house. There is still a loser, right? There's the winners, which are the players, and the losers, that's the house, or vice versa. But there's still winners and losers. But then they go on to say, if you really think about games, games have a distinct start and a distinct end. They don't go on forever. There's not, you always know when they begin and when they end. They didn't start yesterday and you just didn't realize it. You know when a game starts, you know when a game ends. You have recognized rules for the game. You draw a card at this time, you move your pawn at that time, whatever the rules may be. There's detailed rules that govern everybody's actions. And there's an agreed upon definition of a win before you even start the game, right? Before you start the game, you know that win means I have the most points, or win means I own the most properties, or win means I've captured your king, to use different game examples. But that's not what happens in a negotiation, right? In a negotiation, we don't walk in, first of all, for us as mediators, the mediation technically may start at 9 a.m. and end at 6 p.m. on a given day, but the mediation started long before then. We know that, right? It started in whatever exchanges and interactions the parties had prior to our even being selected as mediator. It started when we started interacting with the parties, when they shared information with us, when we scheduled the mediation, and it continues long after the mediation. We may have rules governing the mediation, but those rules don't govern the settlement, right? Those rules don't tell us what that settlement needs to look like. They just tell us, I ask that everybody, not cuss or scream, whatever my rules may be. And so it's very different from a game. And yes, the goal may be to have a mutually beneficial agreement, but that is totally separate from game theory win-win. And that's their point, is you cannot look at a negotiation as a game. It's important. It's something valuable and meaningful to the parties. You have to look at it as something that is different. That's something where you may give to get, but that's not because of a game theory. That's because that's what's helping you move forward. That's what's helping you accomplish your goals. That's what's helping you meet your needs or your interests. So it's really a fascinating way to think about it.
Yeah. I think that pitting, I guess, win-win versus mutually beneficial, that something that is mutually beneficial may not look like what you would typically see or define as a win. Like, if there's a game, people can agree from the onset how long is this game going to last and what does winning look like, right? But in the negotiation, the resulting uh, consequential settlement might be something that those two parties, or multiple parties, if it's a multi-party mediation, those parties consider as something they can live with and accept, and that benefits them. Otherwise, they would not have agreed to it, right? They would have just taken it to court. And so sometimes we'll have a mediation where all that was required was a "I'm sorry." And there might be something that happens that resolves the dispute in a way that no one would ever consider would be win-win, because it's not that strict in black and white, right? So that's why, therefore, it's a myth that people are accustomed, and I don't know why. Maybe it's just human nature that we always want to just see the world in these scenarios of black and white, of win-win, winner loser, David and Goliath. I mean, that's just how we are. But yeah, you're right. Negotiation is a art form in many ways, because what you end up painting and weaving together at the end of the saga can be something that people on the outside might never truly understand, but the people who was walk away with it would consider as mutually beneficial. That's my takeaway. And thank you for the article, because the article you wrote on it kind of pieces that out. Yeah.
And adding up to that, before we close, I wanted to say that that also brings one more thought in me, because we're talking win win. These are very, very harsh words. It's like if you win, you're a winner. If you lose, you're a loser. So, to a degree, if we see mediation in those terms, okay, mediation from on, let us say, custody, right? I am having a part time, I'm a half and half custody. Oh, I'm a winner and she's a loser. That doesn't help to build a long term relationship. So I do believe that in terms of mediation, it will be better to speak about some sort of satisfaction. So not winning, but receiving some sort of satisfaction from the reached agreement. And sometimes the satisfaction might not even be from what is written in the agreement. Mediation also sometimes has just this purification effect, which is we end this entire mess. We end this entire process. We end this entire court that is ruining me on finances and other terms that doesn't allow me to sleep correctly because I just don't have. My mind is not free from thinking about it constantly. So, satisfaction rather than winning in the mediation.
Yeah.
Absolutely. I think that's what's really underlying all of this is that we shouldn't be looking at a negotiation as a win-win because that implies even if you're saying win-win, there's still a loser somewhere. Instead, we should be finding ways that result in an outcome that's mutually beneficial, which is a totally different concept from win-win. And you're 100% right that sometimes the most important part of the mediation is the cathartic aspect of going through the mediation process, less so the actual written agreement that comes out at the end.
Yeah, I hear, transformative mediation and all of this, right? That there's a bigger picture part of it all when you undergo it. And then this is also what sets apart, I guess, shall we say, a good mediator versus, one who hasn't had the experience. And so I guess a good mediator who doesn't see it as win-win would find really creative ways of helping parties resolve their dispute in a way that they might themselves, because they were stuck in the prism of black versus white, and that they might themselves have never realized, oh yeah, that could be a way I could resolve this thing. So I think this is why it's important for for us conflict resolution experts to get savvy and helping people understand. Look, there's what do they say? There's more than one way to skin a cat, right? There's more than one way to do to do a thing, and so yeah, a good topic, and that's basically the two myths today that were attacked, and that is trust is necessary and negotiation is win-win. And so, Sylvia, we look forward to the next one where we'll take on some more. Any other words you want to say before we leave?
Well, I appreciate you letting me share my passion about for reading and the opportunity to discuss this really thought-provoking book. So thanks for the time today.
Thank you for
Awesome.
reading the appropriate books.
All right, guys. Till next time. Bye bye.